Good morning, Mr. Lowndes.
Hi, good morning, Chief Justice Marshall.
I'm sorry, Ms. Manlin, did you get that on?
Good morning, ladies and gentlemen. Basically, this deals with the denial of the right of my client to raise the issue of criminal responsibility. He was so limited in doing so. And since that was the major issue in the case, and since he is clearly very disturbed and mentally ill, that made the difference, I suggest, between guilt and innocence. Let me first deal with the motive issue. My brother concedes that that's a very significant issue. And of course it is in a case where you're raising criminal responsibility, because if there was no motive for doing what he did, then the immediate question that arises, he must be crazy, so to speak. You need a motive, and without any evidence in the record of any motive.
Well, what about, I mean, just in terms of drawing an inference, what about the fact that, I gather the evidence was that your client, that the victim got up in the middle of the night, as did your client. So there was some interaction between the two of them before this happened. I mean, doesn't that give rise in these circumstances to arguing that something happened and maybe that is a motive for what then occurred?
I believe that's a stretch. We don't know why he got up. He
Well,
could have gotten
he
up
got
for a
to
lot
get
of
cereal.
reasons.
Isn't there something about getting a bowl of cereal?
Well, he could have gone in and then lost it when he was in there. Just the fact that he got up at the same time. I mean, that wasn't even argued by the Commonwealth as a basis for a motive.
So what are the facts here are that there were three people sleeping on a mattress.
Right.
And the victim, in this case, got up in the middle of the night before or after your client, or do we know that? At the same time?
I don't believe, I thought there was a time delay there.
All right.
But
At some point, they both returned to bed, and your client brought a knife back to bed, and then killed the victim, and then attempted to kill the other person.
Right.
All right. So, and they had been friends and had been having a nice evening together. So there was nothing in the course of the evening, at least there was nothing in the evidence that in the course of the evening there had been some disagreement or dispute or anything of that sort.
Not at all. An objection was made on this issue. In final argument, the district attorney speculated as to all kinds of things. A crime of passion. There was no evidence that there was any relationship between my client of a sexual nature and that of the second victim that wasn't murdered.
Mr. Rones, could I just ask you a question about that? This is from the Commonwealth's brief, but I'm just, if you could speak of this. It says, Judge Welch found the prosecutor's argument that the defendant harbored romantic feelings for Brooke, was jealous of Matt, and envied the happiness and promise of the young couple was based on the evidence. And you just say that's wrong.
Oh, yeah, there's absolutely no evidence of that.
Did that come up after, in this objection? In other words, there wasn't the argument and then the objection, this was a sidebar about it? I'm trying to figure out when Judge Welch made those comments or findings, if you know.
What were they findings?
It's just as Judge Welch found, so I don't know.
Well, maybe
It's on
I'll
page
let my
41.
brother deal
Okay.
with that issue. I'm not sure when it came up. And you look at the interaction with the police and the surviving victim, the interrogations of those people, no one can come up with a reason. The doctors or the police, as I say, who saw him shortly after the incident, and as I say, the surviving victim. there was just a major question as to why he did this. And for the district attorney to speculate, which we know you're not supposed to do in final argument, speculate in so many different areas. You can draw some inferences, but I suggest there wasn't enough to draw that inference. He speculated it was a conflict with his father, it was jealousy, he's angry, he wanted to hurt somebody, crime of passion. Something probably happened to trigger the killing, he argued. Now, as to prejudice in this case, I suggest it's overwhelming. This wasn't a fellow that had no history of severe mental illness and simply raised this defense because it was the only one to raise.
Isn't part of your argument, though, as well, because it seems to be part of the same part of the closing, I mean, or it gets connected to your second point about making a statement that suggests that the defendant, or drawing attention to the fact the defendant didn't testify at trial? I mean, that he didn't tell us
I'm
that.
going to get to that.
But I mean, they are connected, don't you think?
Yes. There is a connection, definitely. And I was going to get to that. I just wanted to point out, in terms of the prejudice, he tried suicide many times. He had a mental illness. All the experts agreed to that, I believe. He was a schizophrenic. He had had auditory hallucinations on many different occasions. Now, on the failure to testify, the prosecutor said, who knows what was in his mind? Who knows what the motive was? He didn't tell us, he says. Us, who else could us refer to than the jury?
By way of background, is it correct that it was the defendant who called the police and told them?
Yes.
When he made the call to the police, what did he say?
I killed somebody.
Didn't he say I stabbed somebody?
Yeah, I stabbed. But a normal person that does a killing doesn't call the police.
Is there
You
such
know,
a thing
he
as a
runs
normal?
away. He doesn't stay around.
Well, I was just wondering if that was what led to the comment by the district attorney.
Well, I don't know how that
It was
would.
the defendant who reported the crime.
But he says us, and you follow up the next statement he made. He didn't tell us, he didn't tell them. So you don't have us meaning everyone. He's talking about the psychiatrists. He didn't tell them, and assume the police and anyone else, because they all said they never got any explanation. So he says, he didn't tell us, he didn't tell them. So isn't that clear that he's directing his comments, or
But he
intentionally or not, he's suggesting that we didn't hear from him on that issue?
Well, Mr. Steinfeld would say that he says he didn't tell us, all he says is that he heard a voice, and that was clearly referring to the police. You agree with that?
No, I just don't see that. There is a reason you do things. You heard from the experts. He didn't tell us, he didn't tell them. So he's referring to the experts. He didn't tell the experts. And then he goes a step further. He didn't tell us. I don't see how that would refer to the police. Who else would it refer to if you don't consider it as referring to the experts? And he made it clear that he wasn't.
Therefore, essentially commenting on the defendant's failure to testify,
Yes.
directing the jury's attention to the
Yes.
fact that the defendant didn't tell us
Right.
here.
And so that's tied in, as Justice Botsford points out, that's tied into the other significant issue of failure to or suggesting a motive when there wasn't one. Like, look, they say there's no motive. Yes, there was. Basically, and we don't know what it is because he hasn't told us what it is. Another important issue is the instruction, the jury instruction. The judge ignored the standard jury instructions.
You say that, but I went back and looked at the model instructions. You're talking about voluntary consumption of alcohol and drugs, right? That's where you're going, correct?
Voluntary consumption, yes.
Well, I appreciate that the language that trial counsel wanted is from a case heard. Is that right?
But the Heard, it's referred to as the Heard instruction,
Okay.
right?
But so I looked at the model instructions, and maybe I just didn't find it. I just didn't see it in there. That what you have quoted in I just didn't see it in that way. I saw. I didn't see it. But you tell me that that's part of the model
I
instructions?
believe. But in any event, it's the law of the Commonwealth.
But in this case, all right, whether it is or isn't in the model instruction, in this case, is it not so that there was no evidence that the medications or the alcohol, that nothing that your client took exacerbated any mental condition? Indeed, as the district attorney argues, they may have calmed, I mean, certainly the medications were intended to calm him down. So what would be the evidentiary basis for that instruction that you were looking for?
Well, there is some evidence on this issue. There's considerable evidence on the other side that it didn't affect. But you have Dr. Brower, when he testified as an expert, saying that a friend of the defendant has said the defendant said he heard voices while drinking. And you have a lot of evidence of drinking.
I know you have a lot of evidence.
Substantial evidence of drinking.
Right.
So I suggested it was up to the jury to factor that in. You know, they could decide that that affected the ability to form the necessary intent.
Oh, right. I get that. But what you wanted was language about how it could bring on the mental illness in the substance.
It could activate it.
Yes.
It's already there.
Yes.
That it could activate it.
And what is the evidence that it did in any way activate the mental illness?
Well, there's the evidence from the doctor. He said that a friend said that the defendant said he heard voices when drinking. There's certainly evidence there. And as I say, there's substantial evidence of very heavy drinking. So the jury should have been given the opportunity to consider the issue of if he didn't know that this was exacerbating his mental illness, then the jury could consider the alcoholism as impacting the mental illness. Generally, the instruction is, and he gave that alcoholism and the voluntary consumption is absolutely no excuse for
It
or a
doesn't
basis
it
for
doesn't give you lack of criminal
responsibility.
Did someone ask for that instruction? Do you know?
I believe he did ask for that instruction. No, maybe he didn't. I'm not sure on that issue. But what makes it important is the jury came back on this issue.
Right.
And asked a question, so they were very concerned with this particular issue. Alcohol consumption in itself is not a basis. But he didn't put in that language in and of itself. He simply basically said alcoholism doesn't enter into the issue of the capacity to form the proper intent. When it does, there is a interaction.
Yeah, but you're not talking about diminished capacity here. You're talking about lack of criminal responsibility.
Yes.
So forming the intent is a different issue, isn't it?
Well, and the issue was whether it exacerbated his mental illness. And
Activated it.
well, yeah, activated it, right. I mean, it's already there. But if it's activated, you can have mental illness, it's there, but it doesn't play in to criminal responsibility. But here, the idea is if there's alcohol in combination, then at the time that you committed the crime, you were in a different state than simply mentally ill. At that time, you were at a point where you weren't criminally responsible.
Well, I take it that if there was evidence that the mental illness could be activated by either, well, alcohol, let's say, then the question is whether or not the defendant voluntarily consumed the alcohol knowing that it would activate his mental illness.
Well, the instruction was given on that. If he knows that, then it's not in any way, a basis for an instruction to the contrary.
All right.
And he was instructed. Sure, if he knows about it, but what about the person that doesn't realize it? That's what we're dealing with here, and as I understand, the instructions did not give the jury that opportunity to consider alcohol in any way as contributing to the situation where the murder actually took place.
What evidence was there to support the argument that he didn't know that alcohol would activate the mental illness?
Well, there was no evidence that he did.
So why should the instruction have been given then?
Well, the jury might find that he didn't know. There was no proof that he did know. The government has the burden of proof. There was no evidence he did know. And the jury should have the option to consider whether he did or not, even though there was some evidence he might have known. Now, on the issue of the admissibility of evidence that people said that he had in the past talked about hallucinations or hallucinated. I'm not going to get into the difficult evidentiary issue of whether that's admissible, because what happened was the judge ruled that inadmissible, but then he allowed the government to call 4 witnesses that said he'd never talked to them about hallucinating in the past. Well,
But he didn't say it was inadmissible. Your client had a bunch of witnesses who testified, not the 2 that are the subject of the brief, but there were other witnesses who testified that the defendant had said to them that he, in one way or another, was hearing voices.
right, at the time.
But also before. In other words, what I gathered from the Commonwealth's brief was that the judge changed his ruling overnight and broadened the temporal period in which this kind of evidence could come in.
Well, allowed in very recent types of
The argument is made that
testimonies.
one of the witnesses was a year before.
Well, I don't believe so. In any event, to allow in those 4 witnesses to counter what had been said before doesn't seem fair. I mean, there's no time frame to what the other witnesses said. They could have been at any time. They said, he never told us that. And he did restrict some of the evidence
But what wasn't there?
that was going to come in on the basis that evidentiary-wise, it shouldn't come in. And there's a decent argument for that it was hearsay and there's no basis to come in. Of course, I argued it went to the issue of his mental illness, and thus it wasn't hearsay, or if it was hearsay, it was admissible. But our position is it just wasn't fair for him to do that. Now, on the issue of 278-33E, I'll finish up. Oh, I didn't even see that.
I know.
I like talking so much. Yeah.
Join almost everybody else here.
Yeah. Just one quick point. You notice I didn't have a 278-33E argument, so I'd like the permission of the court to submit that.
You may do that, Mr.
And it's maybe timely that I didn't submit it because a recent case came down dealing with mental illness, where for the first time in many, many years, you did use 278-33E to reduce the verdict. So I'm going to deal with that case as it relates to this case, too. Thank you very much.
Thank you, Mr. Lawrence.
Good morning. May it please the Court. Ken Steinfield for the Commonwealth.
Good morning, Mr. Steinfeld.
I would like to begin by pointing out 4 factual misstatements of the record made by my brother. And I apologize, I don't want to appear pedantic, but I think each one of them is important for the Court to understand.
You don't want to appear pedantic? It's okay if you are pedantic?
Precisely.
Okay.
Well, I don't consider it pedantry,
I'm okay.
but it has a superficial veneer of pedantry. He said there was no evidence that the defendant knew that alcohol could have an effect on his medication. In fact, one of the very first...
He said on his mental illness.
Yes, I'm sorry. That it could have an effect on his mental illness. In fact, he told the police that he knew that it was recommended that he not drink while he was on Celexa. So that is definitely evidence that even if it's possible that his consumption of a substance activated his mental illness, he knew he wasn't supposed to drink and do drugs when he was on that medication.
I thought it was your position that there was no evidence.
Oh, yes, there was no evidence. Absolutely not a shred of evidence that it did. But even so, there's no prejudice from the lack of the instruction, because the jury, the only evidence before it was that he, in fact, knew he's not supposed to drink while he's on Celexa. So that's all I'm saying. I strenuously hold to the position that there was absolutely no evidence of activation or trigger.
I know I'm interrupting your pedantic list, but if I could.
Sure.
Just on that point, why was, given that, and I take it that there's evidence that he said, I can hold my liquor, or something to that effect, and no evidence of really impact at all, why was any instruction given on that? Who asked for it?
Well, no one asked for it. It's not contained in the request for instructions that were filed. The judge included it, I think, because there was alcohol raised in the case. Nobody asked for it, and the issue only really arose when the jury came back with a question.
I take it the jury came back with a question after the judge had given the initial instruction.
Right, which were true statements of the law, and as I say in my brief, they were superfluous, perhaps,
it's just
and harmless.
I think one may say that they were perhaps superfluous, but not exactly, they're not exactly in the defendant's favor, put it that way.
Well, but they didn't harm him at all, because it really was not an issue in the case. Defense counsel himself conceded that alcohol did not play any role in this case. I'm frankly at a loss to understand why this claim is even being asserted here when defense counsel, though he asked for the instruction after the jury request, he said, I agree, alcohol didn't play any role in this. And all the experts not only did not say that it didn't activate it, the defendant's own experts said that it had the opposite effect, that it was self-medicating, calming, and the defendant told one of his own experts, I don't hear voices when I drink. That is the second misstatement. My brother said that he told, that the defendant told a friend that he hears voices when he drinks. That is not accurate. The testimony was that when the defendant was drunk, at a time when the defendant was drunk, he told his friend that in the past he hears voices.
Okay.
That's absolutely clear on the record. Thirdly, my brother said that the defendant suffered from schizophrenia. There was testimony that he did not suffer from schizophrenia. The only 3 mental diseases or defects that were even mentioned were depression, temporal lobe epilepsy, and schizotypal personality disorder, which the experts testified are very different from schizophrenia. So schizophrenia is not an issue in this case.
Does it make a difference?
Yes, I think that schizophrenia, although, because I think it is more likely that one would have a psychotic episode if one is schizophrenic than if one has depression. So I think that if there were testimony that he suffered from schizophrenia, the hearing voices and the compulsion as a result of hearing voices would be a better defense. But there was absolutely no evidence of that. And finally, my brother said that there was evidence that the defendant attempted suicide many times. In fact, there was a single suicide attempt December 29, 1997, about 4 years before the incident. I'd like to clarify for Justice Cordy the order of events when the 3 were on the mattress. The defendant got up first to get a bowl of cereal. 5 to 10 minutes later,
Who put in the...
I'm sorry, the victim got up first.
How did it... Who could introduce evidence what the victim was doing?
Brooke.
How did she know that he was getting a bowl of cereal?
Brooke, she testified that she was in bed and Matt was next to her, and Matt got up to get a bowl of cereal, and there was no objection. How do you know that he got up to get a bowl of cereal? It's implicit that he said, I'm getting a bowl of cereal. Perhaps it was his habit. There was no objection, so the jury was entitled to take it for what it was, that he got up to get a bowl of cereal. And then Brooke said that 5 to 10 minutes later, the defendant got up. She didn't say why he got up. She didn't know. And then she only testified that at some point later, first Matt came back to the bed. She sensed someone getting back into the bed, and that person was Matt, not the defendant. We don't know when the defendant came back to bed or if he ever came back to bed, because the next testimony was from Brooke that he was stabbing her.
Is it clear from her testimony that both the defendant and Matt were not on the bed at the same time?
When?
The cereal. In other words, when Matt
Yes.
got up to get the cereal, it's clear that the defendant got up.
Absolutely. The evidence from Brooke was that they were up together in a tiny apartment. And
Okay.
as Judge Welch found, it's a reasonable inference that in this tiny apartment that there was some interaction between them.
But is Mr. Rones right that in terms of the closing argument about motive, that event was not mentioned? Is that right?
Pardon me, that event was not mentioned in the statement that the defendant gave to police.
No, I'm sorry, I wasn't clear. When the prosecutor was making the closing argument, that was the subject of Mr. Rones' argument today, that when he was talking about motive, he did not actually call attention to this getting up with the cereal bowl?
I don't believe he did, but he did say something might have happened between the two of them. And I think implicit in that was at this point when they're up alone together, because something happened between the time that they went to bed and the time that the defendant started.
Obviously, the something could be that he went crazy.
Absolutely. But I think that it is a reasonable inference. All of the possible motivations that the prosecutor spoke about in his closing were reasonable inferences based on the evidence.
Well,
What evidence was there that he might have, that the defendant might have had a love interest in Brooke?
Well, about a year and a half earlier, they had kissed approximately 10
but-
times.
Yeah, but a year and a half earlier, and he's, she's now in a relationship with the victim, and the victim is perfectly comfortable with this. They stay overnight. There's no suggestion. I mean, Brooke was with the defendant from 11:30 until 2.
1:30 to 2, yes.
It was 1:30 to 2?
Yes.
And no evidence.
I'm sorry, from the time that man went to bed to 1:30 or 2.
Yes,
I think Brooks said,
a
right, I'm going to
2-hour
bed.
period.
Yes,
She doesn't say we were engaged in any kind of romantic activity.
That's right.
They're friends.
that's right. But it was very clear from Brooks' testimony that she and the defendant had remained very, very close friends for that period. I think.
Well, very, very close friends. That's fine. But I mean, obviously, with the consent and approval of the victim. I mean,
Well, the victim didn't. Well, they stayed friends. We don't know how the victim felt about Brooks' continued relationship
But the
Matt.
point is, this is all speculation.
It's all speculation.
But I think there's a case that discusses the natural inclinations of human beings. And I think that the fact that they remained friends and that they had spoken for 2 hours about an emotional subject, I think it's a fair inference that he had a romantic attachment to her, that he was pining for her, and that's why they had stayed.
man.
It's not inescapable, I admit. It's not, the question is whether or not it's a fair inference from the evidence. I should point out that the prosecutor made very plain that these were possibilities. And there's a case, the Lucian case, talks about that it's a difference when the prosecutor presents it as a fact as opposed to when the prosecutor presents it
Yes, but
as
the
a
issue,
theoretical
as
possibility.
Mr. Lone says, that may be the case, but the issue here is to try to explain to the jury why this sudden event in the middle of the night. I mean, these were three friends who all three had a close relationship, all three had been engaged in social interactions, and then all three with no objection. I mean, three of them are sleeping together with clothes on, as I understand
Right,
it.
there's nothing sexual implied.
There's nothing sexual, right? They go to bed.
Certainly.
I mean, they go to sleep. And so for the prosecutor to stand up and say, it could be this, it could be that, it could be this, it could be that, if it's not based on the evidence, is fairly dangerous, even if the prosecutor is saying these are only possibilities.
Well, Judge Welch specifically found...
I take it that was an objection after the closing argument.
Well, actually, I was going to get to that because Justice Botsford brought that up earlier, the sequence of events. Before the closing arguments, the defense counsel asked the judge whether he wanted him to object during the prosecutor's closing or afterwards. There was concern before the closing that the prosecutor would engage in speculation, and they had talked about it. Judge Welch said, feel free to object during the prosecutor's closing. I don't understand why lawyers don't do that more often. So during the closing, he objected 4 times, including 2 or 3 when the prosecutor was engaging in what he now says is speculation. They were all denied. And that's why I wrote in that sentence, as Judge Welch found, because he denied the objection. When the objection was speculation, and that was denied, that's the equivalent of a finding that it was fair comment based on the evidence.
He didn't articulate this?
Not until after the closing. During the closing, he just said objection 4 times.
Okay.
Judge Welch had said, don't tell me the reason. I'm not going to go to sidebar during closing, but if you object, I will rule on it. I think it's
Okay.
better to do that contemporaneously, but then we can talk about it afterwards. Then, when the prosecutor ended, defense counsel came up, and they argued specifics, why he thought the prosecutor had engaged in speculation. And Judge Welch there said, well, I think it's a fair inference that they're happy, he's not, they're together, he's alone, and that therefore the inference that the prosecutor had drawn were fair. And I think that the record supports that. As I say, they're not inescapable, but I certainly think they're fair. I also would like to point out that the judge instructed the jury that they're not allowed to engage in speculation, and I understand that's a common instruction. But even more so, this is not common. The defense counsel in his closing begged the jury not to engage in speculation. He said, do not speculate, please, I beg you. So the jury was aware that this was an issue in the case, that the defense maintained that this was improper speculation. And the defense counsel did an admirable job bringing to the jury's attention his belief that the evidence did not support those speculations. I
Well,
think
I take it, since he argued first, that he wasn't saying, when you hear the prosecutor, or was he? When you hear the prosecutor tell you the motive of my client, that's speculation? He didn't say that, did he? It was a general comment about don't speculate.
No. He was specifically talking about motive, the reason for the crime. Because there had been a colloquy before the closing where they had discussed, defense counsel was concerned that the prosecutor was going to engage in speculation. He even filed a motion in limine to preclude the Commonwealth from speculating as to motive. So this was known that the prosecutor was going to do it. The judge knew it. The defense counsel knew it. And I think that there were adequate precautions built in. And there are, of course, many cases that say that a jury is sophisticated enough to separate speculation from non-speculation. I'd like to point this Court's particular attention to the Harbin case, which involved a murder at a crack house between 2 drug dealers. The Court there said that it was a reasonable inference that that shooting had occurred, that shooting had something to do with the sale of drugs, solely based on the fact that it occurred in a crack house and that both the victim and the defendant sold drugs from there. But there's no further evidence of that. And I think that if in that case that is proper speculation, then I think that what the prosecutor said here about the defendant perhaps pining for Brooke and that he was obviously angry at them, or that something happened when he got up.
Why was he obviously angry?
I'm sorry. The number and force of the wounds and the closeness of it. He is hovering over a prostrate victim and stabbing him. It's a very up-close, violent crime. So I think you could find, of course, assuming that he's not acting under a compulsion that he cannot control, that he was angry when he did it. And also the fact that he bent a knife. There are photographs of the knife in evidence that show just how distorted this one straight knife became. It goes off in like a 45-degree angle. And he was so angry that he went to the kitchen and he got another knife before he proceeded to attack Brooke. So I think the statement that he was angry, I think that's fully supported by the record.
What do you, I'm moving on just
Sure.
a touch into the argument. What about this statement, he didn't tell us?
Yes, I think two things. This is a case where I think it matters that it was spoken and not written. And that ties into my second point, the absence of an objection from defense counsel. The record displays an aggressive, defense counsel was on his feet constantly throughout trial, making many, many, many objections. And at times he was chastised by Judge Welch because of his objections, which were not well-based. However, he vigorously defended the defendant's rights. And if he had heard something as obvious and well-known as thou shalt not comment on the defendant's right to remain silent, I think it's a pretty fair bet, and I think the record supports it, that defense counsel, if he had heard it that way, would have objected. He did object 4 times to other things during the closing. He didn't object to that. He objected to other things following the closing, but he didn't object to that. I admit that there is that it's superficially problematic that he said us and them, but I think it is possible for the jury was not necessarily required to see that as a comment on the right to remain silent.
But that's not the test, is it? Whether they're required to see it as
Well,
that?
there is a case that says naturally and necessarily. And so by that standard, no. But there are cases, the Mellinson case and others, that talk about that it's inevitable that an oblique reference to his right to remain silent would not be prejudicial error. The first comment, he didn't tell us. He just said he heard voices. That's clear that he's referring to the previous statement that he gave to police, and that's fair game under Guy, I think.
I don't see it that way, but maybe. I haven't read the whole argument in one piece. So.
Well, when he said us and them, I put forth it's possible, and the absence of an objection makes it more possible that the tone was, he didn't tell us, he didn't tell them, that he was referring to the same entities. Or the us was the police and the them was the experts. And it was fair to comment on what the defendant did or did not tell the police, and it was fair to comment as to what the defendant did or did not tell the experts.
Agreed. I agree
Right.
with that. It's how you use us, but
Right.
okay,
Oh,
I hear you.
Oh, yeah. I definitely agree that that it doesn't look good on paper. But I would strongly argue that because of the lack of an objection, it didn't sound that way to very, very experienced and vigorous defense counsel. Unless the members of the court have any...
Mr. Steinfeld, this is
Yes.
a minor thing. At the back of your brief, you've included a supplemental record appendix with a photo of the crime and the interview of the defendant. Were these admitted in
Yes,
evidence?
they were. Yes, they were.
On the defendant's statement, right at the end, there's some writing. What is this, the so-called confession?
Yes.
Whose is that?
There was testimony. Trooper Brodette, who took the statement and wrote it out, said that when he asked him to sign it, when they went over the statement first and he asked him to sign it, the defendant said, what is this, the so-called confession? So the trooper wrote that at the bottom,
I
because
see.
that's what the defendant had said when he was asked to
Okay.
sign it. And the photograph was part of the record, and I included that. I don't think that it's gruesome. I didn't, there are lots of pictures.
You're just
but I
trying to show the
size.
size?
certainly
The size.
wanted the court to have some idea
Of the size.
how tiny this apartment is, how when they got up together, they had to be together, and that's why I included it.
On that point, Book testifies that he got up for cereal or something. Did she say anything about an argument?
No, oh, no, she had no idea what happened between them.
Doesn't that, I mean, you know, doesn't that go to whether it's a fair inference, and this is a tiny apartment?
Yes, but the key testimony there was she couldn't hear well out of her right ear. So her habit was to sleep on her left ear, and she was on her left ear facing the wall. So the only ear that was out was the ear from which she could not hear well. And that explains why she did not awaken while the defendant brutally murdered Matt. She couldn't hear it, and maybe she was in a very deep sleep. But that's why she was unable to say anything happened. Of course, it would have been better for the Commonwealth had she said, yeah, they got up, they argued, Matt took the last of the cereal, the defendant didn't like it, something like that. But there's no evidence of that, nor would there have been given Brooks' ear problem. I would ask the court to affirm the convictions of all 3 crimes and to deny 33E relief.
Thank you. Mr. Steinfeld, obviously when Mr. Wones submits his letter, Rule 16 letter, if you want to respond to it, you can do so.
Thank you very much. I will.
All right.